At first glance, this moment may seem lighthearted, even humorous, as the judge and courtroom participants struggle with faulty pens. But beneath that brief pause lies something deeper, an early glimpse into the tone of the courtroom. The judge's willingness to acknowledge a shared frustration humanizes the proceedings, subtly lowering tension before transitioning into a much more serious legal matter. These small, unscripted interactions often set the emotional baseline for what follows, reminding everyone present that despite the gravity of the law, the people enforcing it are still human.
You know, I'm not, I'm not the only person having problems with this thing. Michael, Best, he's having, look at this. He's struggling. Look at that. Look at that. The way he signed his name.
No,
I mean, it's the way these pens are, I don't know who made them, but they're hard to work.
Like, do you need
Yeah.
do you need to fingerprint him? It's okay, I just want to make sure. Yeah, thank you. Thank you for asking.
You know, hey, Michael, I'm gonna give it, I'm gonna let you do this again, okay? Because hey, I have the same problems you have on this. It's a struggle.
Yes, sir. It was a struggle.
And we're,
Here, Judge, if you want to just give it to me, I can.
I'm trying to erase it, and, okay. There it is. Okay, here, let Mike sign it right under state's exhibit.
This top.
Yeah, because that was hardly readable, and it's not, I know it's not his fault. I don't get much then. Yes, that works better. Oh. Good. We call now 21-38041, the state of Texas versus Michael Anthony Best. That's you, sir.
Yes.
With Ms. Manavi, your attorney, and the state's attorney, and your probation officer. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in summary?
Yes.
In summary, and by the way, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing, sir, shall be the truth, the whole truth, and nothing but the truth? So help you God. Lower your hand. In summary, this first amended motion to revoke unadjudicated probation, which was filed on December 29th last year, a little over a month ago, this states that on June 19th, 2023, in this criminal district court of Jefferson County, Texas, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is all of that true and correct? Yes. Oh. What do we want to do? First amended one?
Yes, that's what we have. Paperwork.
First amended one states that you committed the offense of failing to comply with sex offender registry on or about January 9th, 2024 in Hardin County, Texas, which is against the peace and dignity of the state and is a violation of condition 1 of your deferred adjudication order, which states do not commit an offense in this state or any other state or the United States. Do you understand what you're charged with here, sir? An agreement has been reached where you would be pleading true to this allegation, first amended 1, failing to comply with sex offender registry. And
As the case is formally called, the atmosphere shifts from casual to procedural. What stands out here is the judge's clarity and efficiency in guiding the defendant through the legal process. Every question serves a purpose, ensuring the defendant understands the charges, the consequences, and the rights being waived. This is not just routine, it's a safeguard of due process. The court must establish that every decision made by the defendant is informed and voluntary, especially when the stakes include incarceration and a permanent criminal record.
Your probation would be revoked. You would be sentenced to 18 months confinement in the state jail. It looks like there's still restitution owed in this case in the amount of $1,280. And that would be ordered on the judgment to, I guess, the complainant in the indictment, this state jail felony of burglary of a building that you indicted on originally and placed on probation. If I follow this agreement, you have no right of appeal of your case. Do you understand this? However, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Are the contents all true and correct? Yes. State's Exhibit 1 tendered into evidence without objection admitted. This states you are waiving any right of appeal. If I follow this agreement, I intend to follow. Okay. Again, how do you plead here to allegation First Amended 1 under this First Amended motion to revoke probation, committing the offense of failing to comply with sex offender registration on or about January 9th, 2024 in Hardin County, Texas, in violation of condition 1 of your deferred order, probation order, which states don't commit a crime. Is this all true and correct as it is alleged? Yes.
Yes.
Are you pleading true and correct to this voluntarily and because it is true?
Yes.
I'm going to follow this agreement, if nothing further, and find that the defendant is pleading true voluntarily, knowing intelligently to this allegation, First Amended 1, as it's placed in this First Amended motion to revoke probation, which is committing the offense of failing to comply with sex offender registration on or about January 9th, 2024 in Hardin County, Texas. And that is a violation of condition 1 of his probation order, which was don't commit any offenses. I find this true by a preponderance of the evidence or greater, and thus your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you had pleaded guilty voluntarily to the underlying offense of burglary of a building, a state jail felony. You were mentally competent to do so. You understood and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that time when we placed you on deferred or unadjudicated probation to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of that state jail felony of burglary of a building. And you are hereby sentenced to confinement in the state jail for a term of 18 months. Also, the judgment shall reflect restitution is owed and placed in the judgment in the amount of $1,280. And that will be ordered to be paid to the complainant who is listed, who is named in this indictment 21-38041 that was handed up by the grand jury on August 4th, 2021, for which you have been placed on probation for and now revoked. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add on that?
Yes.
Okay, we call cause number 25.
Now the seriousness of the violation becomes undeniable. Failing to comply with sex offender registration is not treated as a minor oversight. It is a direct breach of legal obligations tied to public safety. The judge carefully outlines the consequences, including the agreed-upon sentence. What's critical here is the defendant's acknowledgement. By agreeing and pleading true, the defendant is effectively accepting both responsibility and the legal outcome, leaving little room for appeal or reversal later.
5 CR 99, the state of Texas versus John, is it Philemon
Yes, sir.
LaRue? That's you?
Yes, sir.
All right, you were here and Ms. Minaldi is representing you. Do you understand that there's a motion to revoke unadjudicated probation that's pending before the court? And that was filed back on November. And it, among other things, states that you've been on probation since December of 24 for the third-degree felony of evading arrest or detention with a motor vehicle. And it doesn't just allege one, it alleges 11 violations of probation, committing the offense of assault, public intoxication, criminal trespass, public intoxication, disorderly conduct, abusive, profane, or vulgar language, my goodness. Failing to report to probation, to immediately report that you're released from jail when you were released, it says back in October, failing to provide verification to perform community service hours, being at a location other than your residence at 3:15. That's a busted curfew violation in October. Public intoxication in October. That wasn't a good month for you, was it? Failing to enter and successfully complete defensive driving and failing to pay court assessed fees. Okay, it only takes one. You've alleged to have committed 11 violations. It only takes one to revoke your probation. And this is a third-degree felony. So if you understand, you're looking at up to 10 years in prison if your probation is revoked. Do you understand? Serious. You have to speak out so I know. Okay. Let me ask you, do you have any history with psychological testing or psychiatric?
I'm going to be honest with you, Judge.
Well, that's a good thing here. Yeah.
I got in a wreck the 2 years ago. I got in a wreck.
Okay.
And
Did you have a head injury?
Yes, I did. And I don't know what kind of feelings I get over.
Let me ask you, were you in trouble ever before that happened?
No,
Ever?
No.
You weren't even arrested?
I'm not anything bad, like little.
No. That's true. Yes or no? Were you arrested?
No.
Every violation is kind of serious. You weren't in trouble at all before that arrest? Let me see.
Not like crazy.
I don't care, not like anything. I just asked you a question. Did you have criminal history before the wreck?
No.
That's a yes or no? It's like, are you pregnant or not? Yes or no? Not maybe, I'm a little
No,
pregnant.
I mean, I'm just small history. So
Small criminal history. There's such a thing.
yeah, I mean, I was good for a long time. I mean, I was trying to do good.
Okay. We're going back 22 years now. I'm looking at a possession of marijuana in Harris County, 3 days, assault, causing bodily injury in Brazos County. And that was in 05. That was 6 months in jail. Failing to identify. That's 20 years ago. Those are, looks like misdemeanors. Hello. And then we got how many?
This is the turning point. The plea is entered and the judge confirms it was done voluntarily and knowingly. In legal terms, this moment carries immense weight. Once accepted, the court moves swiftly towards sentencing. The judge's role here is not just to punish, but to ensure the integrity of the process. Every word spoken is part of a legal record that could be scrutinized in future proceedings. Precision, clarity, and fairness are essential, and clearly visible in how this exchange unfolds.
Misdemeanor convictions do you think you have? And you said this wasn't serious, but they're crimes. These are above Class C misdemeanors because they're time in jail. How many would you say you had? Because you know better than I do.
I can't remember, sir.
Why?
I don't know.
I would.
7, I'll say.
10. I know more about you than you do. Okay, on felonies, it looks like you were on probation in 2015 for 6 years, and then a month later it was terminated. I don't know what that means. Unsatisfactory termination of deferred probation. How does that happen? What happens?
They just decide not to revoke them.
They just gave
They
up.
just gave up. Yes, sir.
So he was not found guilty. It was
Correct.
okay. And then we've got this present case. All right. Well, here's the deal: is at least you don't have a felony conviction yet. You don't want one. You know how long those follow you around?
Yes.
How long?
Forever.
And a day. Yeah. But I'm a little concerned. You're playing down misdemeanors, but we're not talking about a parking ticket here. We're talking about assaults, resisting arrest, DWIs, resisting arrest, assault. That's violence. All right. You gotta.
In my youth, I was a different man, sir.
Sir,
In my youth, I was a different man.
did you know better?
Yes, sir.
Yeah. You were treated as an adult. Adults, you know better.
Mm.
Were your parents good people? Okay, well okay, you got role modeling in the house, so that was a good example. Anyway. See if you can fix this. But it's gonna take responsible behavior. Okay. And Miss Manaldi is a great lawyer, so what are we gonna do today? What do you want to do today? We know where we stand on what he's facing.
With sentencing complete, the courtroom briefly pauses before transitioning into a second case, one that introduces a very different dynamic. Unlike the first defendant, this individual faces multiple violations, painting a broader picture of ongoing behavioral issues. The judge's tone begins to shift, reflecting concern and perhaps skepticism. When a defendant accumulates numerous violations, it signals a pattern rather than an isolated mistake, and the court must now evaluate not just the offenses, but the individual's overall accountability.
We've got
Intoxications that he pled to, so that's easy.
Okay.
She did file, I think, for an evaluation.
what do we want to do on that, move forward on that? I mean, okay.
I mean, the offer in the case, I believe, is 4.
That's correct.
Last time we talked, I had counter offered with 2, but I don't think that that was accepted. So I think the offer is still at 4 years TDC. So the options that we have moving forward are to accept the plea agreement and go agree to the judge, or we can set it for a hearing and
Then I'll make my
the
choice.
judge will make its decision.
And you're
Same
looking
option
at
that
up
we
to
talked
10
about
years.
before.
But what happens in the calculus is that your criminal history and the circumstances of the charges play together into the equation. Your criminal history is rich, even though most of it's misdemeanors, but you're not supposed to, you're not supposed to commit crimes. Have you ever had an evaluation mentally in front of a psychologist or a psychiatrist or anything like that? No? Has anybody ever told you, any physician ever told you that you should have?
Yes.
That? Well, what happened on that?
I just didn't follow through with it.
Well, I mean, do you think you need one?
I probably. I mean, it wouldn't be a bad idea.
Well, have you ever had like a head injury or anything
Yes.
like that?
I thought I got in that wreck, and after I got in that wreck, I just went.
Okay, in the wreck, what was the diagnosis?
I didn't go to the doctor. I should have went to the doctor.
Well, you can self-diagnosis.
Well, it was a bad wreck, and I walked out of it, and I knew I shouldn't have. I knew I should have went to the doctor, and I didn't go because I didn't have the money.
Right. Okay. So what I'm going to do is grant a motion for a mental evaluation. And Dr. Edgar Pond, the licensed psychiatrist, will come evaluate you for a competency to make sure that you don't have issues that would prevent you from clear-headed thinking in moving forward, in this case, whatever direction we take, because this is your life. And so I find good cause to grant it, and I urge you, he's a very nice man. He's the leading psychiatrist in the area, and he'll evaluate you, work with him, and be frank and forthright. Okay. That's yes or no.
Yes, sir.
Because that's the only, you got to help yourself to some degree. And being forthright is the right way to do it. Don't try to trick him. He's pretty good at catching that, but nonetheless, I'm granting it. And then we're going to come back and review this in a few weeks after that's done and see what direction we take on Mr. LaRue. Anything else?
There you are.
That is all. Thank you.
Yes, sir.
This case ultimately reveals 2 very different paths within the justice system. One defendant accepted responsibility and received a defined sentence, while the other presented a more complex situation involving repeated violations and potential mental health concerns. The judge's decision to order a psychiatric evaluation demonstrates a balance between accountability and fairness, ensuring that any underlying issues are properly assessed before a final ruling. It's a reminder that justice is not always immediate, but it must always be thorough. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.